Good afternoon, everyone, and welcome to this webinar on state responsibility. I am Dr. Rosana Garcia-Ndia, Research Fellow at BICL and Lecturer in Public International Law at King's College London. And together with my colleagues, Dr. Jean-Pierre Gauci and Dr. Richard Scott, who's based at the Bingham Center for the Rule of Law, I am very pleased to convene this event with a great panel of experts this afternoon. The Articles on State Responsibility for Internationally Wrongful Act, developed by the International Law Commission, turned 20 this year. And many key questions arise in this anniversary about their use, their evolution, and their potential in different contexts. We hope that this webinar will contribute to that ongoing and we think very necessary debate. Thanks to all the participants joining us from all over the world. It was very exciting to go through the list and see so many familiar names and others that we are very much looking forward to engaging in discussion with. Special thanks to the public international law firm Volterra Fietta for their support to this webinar series, and to our chair and speakers for so kindly agreeing to be with us today. I would like to remind you that the webinar is being recorded and that if you have any questions as we hear from the panel, you can post those questions or comments in the Q&A chat. Without further ado, I'm very pleased to introduce Professor Philippa Webb, who will be chairing the event and with whom I have the pleasure to work. Philippa Webb is Professor of Public International Law at the Dixon Poon School of Law and a barrister at 20 Essex. Previously, she held positions in the Presidency of the International Court of Justice, the Office of the Prosecutor at the International Criminal Court, and the UN headquarters. She is a member of the PIL advisory panel of the British Institute. And as many of you, of course, know, her publications include The Right to a Fair Trial in International Law with Amal Clooney, Oppenheim's International Law with Rosalind Higgins, Dapakande, and others, and The Law of State Immunity with Hazel Fox. Philippa, thank you very much, and over to you.
Thank you, Rosanna, and welcome to everybody. So on the 9th of August, 2001, the ILC Articles were adopted, and it was a different world. It was a month before the attacks of September 11. Donald Trump was merely a real estate developer in New York. The closest thing we had to a pandemic was an outbreak of the West Nile virus in the US that led to 284 deaths. The UK had just ratified the Treaty of Nice, creating a framework for the expansion of the EU, and Foreign Secretary Jack Straw welcomed enlargement as being necessary to a safe and successful Britain. There was no Facebook, no Zoom, no webinars like this. So we have 3 distinguished speakers with us today to take stock of the last 20 years and also to look ahead. They will each speak for 15 minutes and we will have time for questions. Please put your questions in the Q&A box at any point during the presentations. So I'll introduce them first before giving the floor. So Professor Christian Tams is Professor of International Law at the University of Glasgow, and he directs the Glasgow Centre for International Law and Security. He's also an academic member of Matrix Chambers and has acted before the ICJ, the Iran US Claims Tribunal, and arbitral tribunals. His scholarship focuses on dispute settlement, investment law, and of course, state responsibility. Recent works include the new edition of the Statute of the International Court of Justice and self-defense against non-state actors. And 20 years ago, he was a young assistant working with Professors Bruno Zemmer and James Crawford at the International Law Commission. He will speak about the general framework of state responsibility, emphasizing how significantly the ILC has shaped our thinking on the topic, decisively moving it away from causes of actions and sectoral approaches. Our second speaker will be Mr. Gunjan Sharma, counsel at Volterra Fietta. He represents states and private interests at the highest levels of international law. He has represented states before the ICJ, advised states during treaty negotiations, represented states and investors in arbitrations, and also served as an expert witness on international law issues. He also counsels clients on maritime and territorial disputes and he practices before a wide variety of commercial arbitration tribunals as well as US courts. And he will speak about the attribution of conduct relying on insights from investment arbitration. Dr. Kristen E. Boon is Miriam T. Rooney Professor of Law at Seton Hall Law School and a Senior Visiting Fellow at Osgoode Hall Law School. And she specializes in public international law and international organizations. She's written widely on international legal issues, including, of course, on responsibility, accountability, access to justice, and arbitration. She clerked for Canadian Supreme Court Justice Ian Binney and was a litigation associate at Debevoise and Plimpton in New York. And she will discuss issues around state-owned entities and also make some remarks about developments generally in the field of state responsibility. Before we start the panel properly, I want to acknowledge the sad and recent passing of Judge and Professor James Crawford, a longtime supporter of the British Institute and a member of its Public International Law Advisory Panel. As we know, in 1996, James was appointed Special Rapporteur on state responsibility at the International Law Commission. He was the fifth person to hold that role, and the work on that topic had been ongoing, some would say struggling along for 4 decades. And he brought the project to completion within 5 years, with the articles and the invaluable commentary, forming a blueprint for the law. As Judge Simmer has noted, it was with intellectual courage and resolve that James Crawford led the Commission to reach this goal. And just one indicator of the success and influence of the ILC articles is that they have been cited in over 350 cases in national and international courts. They've been cited by investment tribunals, international human rights bodies, the ICRC, and regional courts. They appear in UN resolutions, in treaty body general comments, in NGO submissions, in council's arguments, in parliamentary inquiries, and of course, in scholarly work. Now, of course, that may just mean mere references or signposting, but often there's deeper engagement and adaptation, something our panelists will discuss this evening. So as we reflect on where we are in terms of state responsibility, we are here largely because of James Crawford's skill and hard work. And as we consider where to next, his legacy, of course, looms large. And I now give the floor to Christian to address the general framework of state responsibility.
Thank you very much, Philippa. Hello to everybody. It's a pleasure and a privilege to speak to you today about this topic. I would associate myself with a lot of nearly everything that Philippa has just said in opening. This is 20 years ago. It feels ages ago, a different era, certainly a very different Christian terms for that matter. I would also associate myself with the remarks more sincerely she's made about James Crawford, who for me was a mentor and a formative figure in whose shadow we all are as we speak about state responsibility. Now, my focus in this first of our 3 panel presentations will be on the first part of the question that the organizers have chosen for us. I will speak about where are we, not yet about where are we to go next. Where are we? That is my question. And my short answer in headline points, if you want, is we are overall in a good place. We have in the ILC's text that Philippa has introduced a generally accepted framework of reference. It is a framework with some problems, with gaps, perhaps, and this is something that I think my colleagues on the panel will explore. It is a framework that needs finessing and adapting, but we have a common denominator, a framework that largely structures the way we discuss state responsibility in all the various areas that have been mentioned already, a language in which we speak about it. This is a significant achievement, and that really is my main point. In my 15 minutes, I hope to do 3 points, 3 things. First of all, I will say a bit more about why I consider this significant, the movement to a common framework, a shared language of addressing state responsibility. It may seem somewhat banal or basic, but I would suggest it's not so banal and not so basic after all. So that is my main point. My 2 other points I will address more briefly are, I will briefly say why it's not just significant to have reached a common language, but it's also, broadly speaking, a good language, a breakthrough towards a more open discourse about state responsibility that reflects changes in international law more generally. And lastly, I would say something about a topic that always comes up when we discuss the ILC's text, and which for the purposes of my presentation is largely irrelevant. And that is the question of whether these articles in and of themselves are binding or not. As some of you may be aware, and again, as we will no doubt discuss in the next minutes, the text was recognized in a General Assembly resolution, but it was never put up as a treaty. And many people obsess, agonize, and have firm views on whether that is a good way forward or a bad way forward. And I also have firm views on that. But for the purpose of what I want to speak to you about, the idea of a shared framework of reference, that does not matter at all. So that is my third point that I will briefly develop. First, then, the significance of a common language on state responsibility. Why does this matter? It seems to me, in one word, it's significant because the ILC's process from the early years of the 60s to 2001 has had a massive streamlining effect in the way in which international lawyers talk about responsibility. Over the time of the ILC's work, the concepts, the terms it's used have trickled down. They have become universally accepted. In James Crawford's words, the ILC has encoded the way we think about state responsibility. We speak its language, including where this language is completely bizarre, complicated, technical, and devoid of tangibility. Internationally wrongful acts, circumstances precluding wrongfulness, attribution, reparation, restitution, compensation, injury, countermeasures, not really sort of terms that make international law exciting or sound like a field that you should engage with, but all terms coined or popularized by the ILC and nowadays the jargon. We may disagree on how they are to be construed, and this is something that my colleagues will speak to, but the concepts are there and the terms are there, and at least in general international law, you cannot really discuss state responsibility without using the ILC's language. Now, you might say that's perhaps a bit banal, labels if you want, but is it really? Let me make two attempts to persuade you that it's not banal, but actually a significant achievement. The first is takes us to the architecture of this text. The ILC has convinced us of using state responsibility and responsibility in a way that is by no means obvious. Its text sets out responsibility as an omnibus notion. It's the automatic consequence of every breach of international law. There's no distinction between crime and delict, something that the ILC toyed with at one point, and there's also no distinction that we know from many domestic legal frameworks, depending on whether the breach is one of a contract or treaty, or a delict, or a breach of custom. None of this matters. We have one omnibus notion of responsibility. This omnibus notion, as encoded by the ILC, is a bit bland, really, largely because the ILC excised from the text all references, or most of the things that we would expect to hear about when we talk about responsibility in other contexts outside international law. There's nothing about duties or rights or obligations of states. The ILC, in the famous terminology, was to codify secondary rules of responsibility, not the primary rules, the concrete obligations. Okay, you might say that's a choice. But at the same time, the ILC made another choice. It felt it could distill very meaningful secondary obligations that go to the defenses, to the remedies. We have very clear, concrete prescriptions as to what states can invoke as a defense in international law, as secondary rules: consent, self-defense, countermeasures, and others, but not other things that are not mentioned there. It's a very strange balance between the absence of core primary duties and obligations and the very real presence of concrete rules on defenses, on attribution, on remedies. The ILC, you might say, vacates the center ground of discussing claims and disputes, and it tells us very clearly how such claims are to be advanced, on how such claims are to be defended against, and how such claims are to be brought and what remedies they can result in. And again, this is now completely accepted. I'm not saying for a minute it's wrong. Of course, it's a plausible way of thinking about responsibility, but it strikes me as by no means obvious We do it all now. And this is largely because the ILC imposed or persuaded us to use responsibility in that sense. Perhaps a second and a brief addition to that, still in terms of trying to persuade you that this was actually really a significant achievement. You might say, well, it's a choice, we all went along with it, but let me persuade you that for a long time, especially in Britain, and especially perhaps relevant for a talk at the BICL, it was by no means the shared understanding of responsibility. And my three character witnesses for that point are three members of the UK triumvirate in international law in the 20th century: Ian Brownlee, Malcolm Shaw, and Philip Elliott. Very different in their approach to international law, in their visions for international law, but united for a long time in their skepticism vis-a-vis the ILC's approach, the idea of encoding state responsibility. The ILC did it. A brief word on that. Philip Elliott, many of you may be familiar with a famous article he wrote in the 1980s, State Responsibility and the Unmaking of International Law. It was a scathing critique of a technical approach which denuded responsibility of real issues. But there was another aspect to that. Philip Elliott was completely puzzled by this idea of why one could obsess so much about a notion, responsibility, which he said was somewhere between illegality and liability, but which in and of itself, in his view, didn't really do much work. Elliott thought it was rather useless, I think it's fair to say. He might have chosen a more polite or a better word for it, but I think he was not persuaded by this at all. Ian Brownlee's take was different, more hands-on, but equally skeptical. In 1983, Ian Brownlee published The System of the Law of Nations, State Responsibility, Part 1, a big treatment on state responsibility, almost coterminous to the ILC finishing its work on what was then Part 1 of the ILC Articles. So at the same time, but it reads like a different world. Brownlee looks at state responsibility through causes of action. What are the claims that you can bring? He identifies remedies. He talks about difference between contractual and delictual remedies, something the ILC didn't want. He spoke about evidence, the process of advancing claims. He didn't buy into the idea that there could be a general omnibus notion. It's a different world of responsibility if you're reading Brownlee, published in 1983. Now, I'm not saying Brownlee might have said it's a lot less bland, it's a lot hands-on. I'm not in for the judgment here, but merely to state that had Ian Brownlee encoded the law of state responsibility, we would be talking in very different terms, in very different concepts, in a very different way. Now, Ian Brownlee has not encoded the law of state responsibility, the ILC has. And in my third character witness, if you want, Malcolm Shaw, we see the power of the trickle-down effect that has come with the ILC's effort at persuasion. Until I think the third edition or so of the Shaw textbook, the famous one that we all, most of all, use, there was not really much about the ILC's approach to state responsibility in the textbook. Responsibility was approached through treatment of aliens, injury, and perhaps also causes of action. But then Shaw's textbook took on board the ILC's approach, and now it offers a fantastically instructive treatment. This is relatively recent, and it took perhaps 2 decades. And I suggest it shows the power of the ILC's persuasion in getting international lawyers, including those that had initially not been thinking in general terms about responsibility, to come on board. So I think it does matter. The ILC's approach has overcome resistance, has persuaded, perhaps especially in Britain, with its fascination, which for me as a German trained lawyer is somewhat unfathomable, with causes of action and remedies. Now, overall, and this is onwards to my much briefer second and third points, overall, I think the overcoming of resistance by the ILC has been a beneficial development, even if it has made the discourse about responsibility somewhat bland and not so hands-on always. It has effectively, I think, adapted responsibility to a 20th century vision of international law in its multilateral era, in its public era. And 3 few buzzwords, not more than that, to indicate what I mean. And I'm happy to pick up on that in the discussion, of course. First of all, it's often said that the ILC's vision of responsibility looks at objective responsibility. You don't need to prove fault or damage, at least not at the general level. It may be that certain rules require you to prove that, but not in general terms. And I think this has been a key step towards adapting responsibility to an international law that works with multilateral and collective interest obligations, where damage doesn't really matter in the way that it matters in a bilateral claims context. Secondly, complicity, Articles 16 and 17 in the ILC's text. They are the first serious attempt to come to terms with the idea, again, that we don't really always have one claimant and one respondent, but we may have bystander responsibility. We may have a duty not to be neutral. We may have complicity and responsibility resulting from that. Again, a relatively novel development in broad areas of international law and something that wasn't really captured before the ILC put it on the map. And finally, briefly, a topic on which many people have written and spoken, the idea that public interest claims could be brought by those that have an interest that is not a subjective right, not a damage, but in the collective interest. You could bring action, you could invoke responsibility. This is something that James Crawford emphasized in particular as a modernization of the code of responsibility in Article 48 of the ILC's text. One final word on my third point, and really just sort of very briefly, how have we come here? How has this happened? It seems to me really one of the more interesting lessons about how international law develops and evolves. It's a trickle-down process. I think Philippa has captured it exactly when saying there is a text out there, it's being picked up on by others, law appliers, law interpreters, the language is used and it becomes ingrained, it trickles down, and all of a sudden it is the language. But what is absent from that process is force or bindingness. This is an offer that is being made to speak about a particular topic in a particular language, and it's not binding on law appliers. You just use it because it's a useful way of capturing a particular area of law. Now, it's an interesting example of how international law evolves through agenda setting, through developing a language that others pick up on. It's an interesting example also of how you can mainstream discourses through a mix of power, because it's after all the ILC, not just me saying it, and persuasion. I think we learn a lot about the role of the ILC as a site where discourse about international law is shaped. And importantly, and this is the point I wanted to make in concluding, all of this works without any formally binding text. Now, as I said, people have firm views on whether there should be an ILC treaty on state responsibility or not. And I might have views on that if challenged. But it seems to me that for the purposes of the language, the encoding, none of this matters. Encoding has worked perfectly, perhaps even better, with a non-binding text. As a coda to this, the ILC's project on responsibility is often compared to the twin or the sister project, the law of treaties. And the law of treaties is a text, the binding text, the Vienna Convention on the Law of Treaties. And people say that what the ILC did with the law of treaties should be mirrored in its approach to state responsibility. But it seems to me that if you're looking at this from the perspective that I've been wanting to emphasize today, the idea of encoding our thinking about international law, the Vienna Convention example doesn't really work. The Vienna Convention, of course, is a treaty, but it's a pretty poorly ratified treaty. 116 states in 50 years, that's not successful ratification. And still, the Vienna Convention is fantastically successful as an encoding exercise. So it seems to me it doesn't serve as a counterexample for how we should approach the ILC's text on state responsibility. Both can work perfectly well. Both can perfectly well encode without being binding as a matter of law. These are my 3 points. These are my 50 minutes. Many thanks for your attention, and I look forward to pursuing this in the discussion after having listened to my fellow co-panelists. Many thanks.
Thank you, Christian. And I'm sure we are going to come back to some of the issues you've raised about form and authority in the discussion. I see some questions coming in. I encourage the audience, I know we have a very healthy audience, to put more questions in the Q&A box for our speakers, as we will come to that after our third speaker. But I now give the floor to Gunjan.
Thank you, Philippa. Thank you, Christian, and thank you to Bickel for inviting me on this very interesting and excellent panel. To continue from what Christian was saying, I want to discuss a particular aspect of the ILC articles, which has really intrigued me, both as a theoretician, as an academic, but also in the practice of investor-state arbitration, which is one of the most commercially minded forms of public international law. And that's this tension between the ILC articles as secondary rules and the way they've encoded how we talk about wrongfulness, and the structure and the way they work with attribution to a state. And what do I mean? Well, my thesis in this presentation is very simple. It is that in some distinction to the structure of the ILC articles, in fact, what's happening today before investor-state tribunals and other areas of international law is the concept of the unitary state, that once you've attributed conduct to the state, then you analyze whether that's a breach, is cracking. And it's becoming more and more important as a matter of international law to see which state actor is performing which action in order to judge wrongfulness. And this is in a little bit of tension with the ILC articles, which I'll show in a second. It's important to remember what the ILC articles are meant to do. The ILC articles are not about lawful conduct. They are meant to encode a process by which we can analyze at a secondary level, as Christian said, wrongful conduct of a state. So one of the most important articles in the ILC articles, and perhaps one that is not discussed as much, is Article 2. And Article 2 sets up a three-part test to determine wrongfulness. And it has two factors, but it's a three-part test. First, there has to be conduct, whether of an act or omission. And conduct means there has to be human agency. And this gets lost a lot. It's getting lost today a lot. In investor-state arbitration, it gets lost when investors bring claims based on the collapse of a housing bubble or a Ponzi scheme or an economic collapse or maybe even political chaos, because that's not really conduct. That's just a fact of life. That's just an act of God. That's a meteor strike. You can't get wrongfulness from a meteor strike. Once you've established human agency in the form of conduct, you then must, under the ILC articles, perform two disparate analyses in order to reach wrongfulness. In 2A, you have to show the conduct is attributable to the state under international law, which effectively means under the rules the ILC articles are going to give you very soon. So that's a pass-fail test. The conduct has to be attributable to the state, and that's one analysis. And then in the way it's structured, you turn the page and you do an analysis of breach. You identify an international obligation and say the conduct constitutes a breach. And what's very interesting, and it might just be simply a function of having a written text, right, is the way these analyses are approached is as if they are disparate and separate, as if there's a gulf, a valley between them. In many theoretical applications and also many pleadings, you see attribution as a section and then breach as a section. An attribution is a pass-fail test. Can you say the conduct you've identified is attributed to the state? And then you must look at breach separately by identifying an international obligation. And my thesis is that in investor-state arbitration, but also international law generally, that valley is not so deep, right? The gulf's not so wide. There's a lot of bridges. The river's running through, and it's a muddy river, and the water's eddying, and these things are mixing together. And I'll give some examples from investor-state arbitration. So just very quickly, if you read the ILC articles and the articles specifically relating to attribution, they're in a separate section to breach, to wrongfulness, to breach an international obligation. And they effectively say, here's the test for your pass-fail. Is the conduct that of an organ of the state, another organ of another state at disposal? Is it a non-state organ, delegated governmental authority? I won't go through all of these. I mean, there's going to be there are some very interesting questions with respect to effective control and direction today. Like, what's the degree of control over the entity versus degree of control of the activity? That's all very interesting. But my point on this slide is more simple. Here are the articles that define attribution, and you'll see that none of these articles depend on the nature of the international obligation at play. So if you were to read the ILC articles as secondary rules, they seem separate and distinct from breach. And here's key. If we analyze bilateral investment treaties and investment treaties, the same is true of breaches in the large part, because the interpretation of bilateral investment treaties is effectively governed. Christian made reference to the VCLT, Vienna Convention on the Law of Treaties. I make reference to it here. And Article 31.1, the primary means of interpretation, is in good faith in accordance with the ordinary meaning to be given to the terms of the treaty in context and light of purpose. 31.4 has special application in investor-state arbitration. Special meaning becomes very important because a lot of these treaties use the same terms, so they're given special meaning. And of course, you have the supplementary means of interpretation, which many common law lawyers in this field kind of give a little more prominence to than might be medicinal. But the reason I'm putting this up is because the number one form, the number one method of interpreting a bit is and remains the good faith meaning, ordinary meaning of its text in light of object and purpose. And if you read, for the most part, here we go, the basic international obligations commonly found in many bilateral investment treaties, and some modern treaties don't take this approach, they take other approaches, but in the traditional bit, the articles that protect the investors presume a unitary state. What do I mean? They say each contracting party as a whole, without reference to a particular organ, shall ensure fair and equitable treatment. Each contracting party shall accord full security and protection. Neither contracting party as a unitary state will take measures depriving nationals of, will conduct an expropriation outside the Hull formula. So the bits themselves are kind of laid out in the way you think of the ILC articles. There's attribution. Once you've got it within each contracting party's conduct, you then have to evaluate breach. But in actuality, many tribunals are faced with a situation where they have to analyze which organ of the state conducts the activity in order to assess breach. In actuality, this concept of the unitary state, this concept that you pass-fail attribution and then you look at the measure for breach, doesn't really work. Here's a great example from customary international law. Denial of justice. In denial of justice, a customary international law claim, when you claim breach by a state's judicial system, the deference given by international tribunals to the independent judicial function makes it more difficult to show the breach. You need to exhaust local remedies, and you need to show a willful disregard of due process of law, which shocks or surprises a sense of judicial propriety. Now, that's a customary international law definition. And the tension emerges when it's understood, everyone agrees, denial of justice is part of fair and equitable treatment. But if you go back to the slide in your minds that I just did, the fair and equitable treatment standard doesn't distinguish in most treaties between the judiciary and the legislative and the executive. So the question becomes, does these hurdles, do these limitations still apply to a claim of breach by a judicial system in light of the treaty language? And the answer is the tribunals have separated on this point. The vast majority of tribunals continue to hold, quite possibly correctly, I'm not going to take a position, they've continued to hold that the hurdles for denial of justice in customary international law apply despite the terms of the fair and equitable treatment clause relating to the unitary state. But that's not a given position. And you'll see in a decision like Bagat v. Egypt, they took the other approach and they said, no, hold on a second. Nothing in the clause says the judiciary is given special treatment. We're going to analyze it just as if it was a legislative act, just as if it was an executive act. Now that's more rare. Fundamentally, it's more rare. There are very few decisions which take this approach. Bagat might be the only one, to be frank, without some kind of way to distinguish. But it's there. Similar thing happening with denial of justice and expropriation. Remember, my thesis is that unlike what you would expect from the ILC articles, the organ to which conduct is attributed impacts the analysis of breach. And you see it for denial of justice and expropriation. There's a real question. If the judiciary expropriates your investment, does that trigger the expropriation clause on its face, or are there additional requirements brought in by 31.4, special meaning, etc., that you have to satisfy? And again, a distinction between the tribunals. Eli Lilly said it might be possible that, yeah, a judiciary can invoke expropriation in its basic sense, versus other tribunals which have said, no, you have to go through denial of justice. A great example is the formation of an investor's legitimate expectations. Right? If you think about it from the ILC perspective, once you've got any entity of the state giving you a piece of paper that says your investment will be approved, this license will be given, that should be it. Yet the promises you can rely on as an investor depend in large part on the internal configuration, whether it's intravirus to the entity giving the promise. So again, this distinction between attribution and breach is muddied. The bridge is formed. Now that's all well and good, and an easy way to think about this is, well, maybe that's just implied in the definition of breach. Maybe we're using these special meanings which have these kind of understood norms, and so breach now relates to different organs differently. So we're imposing our view of these terms into the treaties. But I'm thinking about, as a practitioner, what the implications of what I'm talking about might mean. The ILC articles, public international law, are meant to be attribution agnostic. They are meant to give no consideration to the internal form of the government, democratic, communist, dictatorship, tribal, what have you. The internal form of the state is meant to be irrelevant to the analysis of responsibility, as is the internal organization of the state. That's a rule of law that we repeat in public international law 101 classes, right? Basic question. But if we're starting to bridge the gap between attribution and breach, that's getting muddied as well. Is there a difference? So here's some questions. Is there a difference between regional constituent elements and national organs in relation to the activities performed? Are bits more applicable to the federal government than the state government? Are developing states being held to a lower standard because they don't have capacity? Or conversely, are they being held to a higher standard because they're given less deference by tribunals? Are democracies being given more deference by international tribunals? Does it make a difference that it's an act of parliament instead of an act of the Politburo? I think what we're seeing in practice is the ILC articles are a fantastic codification. There's no doubt. It really helps everyone think through the process. You've got a three-part test: conduct, attribution, breach, and then of course remedy. So four-part, and it's great to lay it out. And people need to be more precise about that. But in practice, is that structure always followed in investor-state arbitration? That's the question in the thesis I've proposed. So I want to thank you all for listening. I hope I stuck within the 10 minutes, Philippa, or 10 or 15 minutes. I tried to do so, but that's it. And of course, please put any questions into the Q&A.
Thank you. Yes, perfectly within the time limit, and actually leading us very smoothly onto Professor Christian Boons' arguments, which also deal with the structure of the state and the behaviour of the state, and some disconnects there with the ILC articles. Over to you, Kristen.
Thank you very much. Good morning from Toronto, everybody. It's wonderful to be here. I would like to echo what some of the prior panelists and what Philippa said with regards to the influence of the Articles on State Responsibility. I wholeheartedly concur that they contain basic background rules that have given us a code and a language for responsibility. In addition, they really do apply to various areas of law, including the law of the sea, trade law, human rights law. And if you're interested in seeing where their application has been charted, the Codification Division of the UN every couple of years issues a new document looking at their where they're cited. And the most recent one is from 2019, and that's UN Doc A/74/83. And that gives a good oversight of which provisions and also which fields of law they come up. But one of the task that we've been given to today is to discuss where to next. And that's what I would like to focus my comments on. I want to give some ideas about where the Articles on State Responsibility, despite their great influence, may not be fit for purpose. And so in that context, I'll make 3 different points. First of all, I'll discuss developments which have surpassed, so to speak, the Articles in the 20 years since they were commended to states through the General Assembly. I'll discuss areas where new approaches to attribution have emerged, and I'll conclude with some comments on what the future might hold for particular articles, particularly the articles on attribution in the context of state-owned entities, because that is a hot new issue, and we're seeing a lot of disputes and cases arise which involve sovereign wealth funds and state-owned entities. So let me begin by making some comments about the first point. How are the Articles on State Responsibility showing their age? Well, one way to think about this is that they are under-inclusive. The Articles on State Responsibility apply to states. There are different rules, of course, that have developed through international criminal law that apply to natural persons. There are articles that have been offered for international organizations, the Articles for Responsibility of International Organizations, that apply to activities of IOs and sometimes states. But for the large part, multinational corporations, rebel groups, non-state actors are really not touched by the Articles on State Responsibility unless one can demonstrate some sort of link, some sort of control that the state exercises. And so I think that it's fair to say that if one looks at the gamut of international actors on the world stage, the Articles on State Responsibility only apply to some of them, which has led to the critique that they are under-inclusive and that we still today are lacking a unified system of responsibility that applies to all different actors on the world stage. Another way in which the articles are showing their age is that they are, in some senses, outdated. They don't reflect the growth of the field of human rights. They don't reflect the internet. They don't reflect the prominence of non-state actors in certain areas. So I think cyber warfare is a good example of this. In the past, rebel groups would need to access tanks or hard infrastructure and machinery in order to be able to launch a war. Today, you need computer. You need just access to technology in a way in order to be quite effective in the cyber warfare context. And importantly, they don't address two what I think are quite disparate trends. On the one hand, we have the rise in influence of state-owned entities, as I noted at the outside. The Norwegian pension fund holds $1.3 trillion US in assets. China's investment corporation fund manages a similarly large amount of assets. And this is really a growing sector of the economy. And although the commentary to Article 5 of the Articles on State Responsibility notes the importance of parastatal entities and certainly anticipates the fact that states will sometimes operate through other entities, I think that the explosion in this area was really never anticipated. On the other hand, I would say that there's also a different theme that we see, and that is that there's a trend of privatization and the hollowing out of the state. And so we have witnessed over the last 15 years really efforts by states to pass off ownership or control of certain areas. Health, education, immigration are certain examples of that. And certainly in former communist countries, this has been a very common aspect as well too of trying to pass off the regulation and the authority of certain areas of governance. And so the articles on state responsibility in a way sit between these two trends, the rise in some areas of the world of state-owned actors, and conversely, this trend of privatization in others. And I think that the strength of these developments was really not foreseen at the time the articles were written and commended to states. So I think that it's fair to say that the articles on state responsibility really depart from the premise of a limited state. They explicitly say that state responsibility is actually hard to prove. It's the exception, not the rule. And so a third critique that has emerged with regards to the articles on state responsibility is that they may create a perverse incentivization structure. They may, in fact, encourage states to try to work obliquely through non-state actors to try and outsource certain functions. And because the attribution tests really do create a high bar, states can, in certain circumstances, avoid legal responsibility in these circumstances. And so that has been the basis of what people call the accountability gap, the difficulty of bringing claims before international tribunals if the bar of state responsibility is not actually met. So if those are the problems, what approaches have emerged? What are the new ways that we see states or other actors dealing with this? Well, I think one prominent response has actually been to create new rules in certain sectors of law and of the economy. And this makes sense because the articles on state responsibility are secondary rules. They're meant to operate in the background. And so in circumstances where states believe that different rules need to apply, of course, they can do that through treaties or other instances. And some examples of that would be Article 139 of the Law of the Sea Convention, which makes states responsible for acts of subcontractors. The Outer Space Treaty has a similar provision. It was widely commented in about 10 years ago when the Security Council was starting to pass different resolutions on terrorism, that the Security Council was also filling the gaps with regards to terrorist activities by being quite specific in Security Council resolutions about standards of attribution and what states needed to do in order to prevent or control terrorism. A more recent example would be recent trade and investment treaties. I think it's quite interesting to see that the Comprehensive Investment Agreement between the EU and China, for example, contains very specific rules now about entities and what standards are required to attribute the acts of an entity to a state. And in particular, it specifies that entities in which a party directly or indirectly have 50% ownership or the ability to control the enterprise, that will constitute an act of a state under those circumstances. And certainly CUSMA and other more recent trade and investment treaties take a similar approach in trying to be quite specific with regards to what the standards of attribution will be. So just to wrap up that point, we see that in certain specific areas of law, treaties now are having or including very specific rules of attribution that displace the general rules that were proposed by the ILC in the articles. Another strategy has been to try to fill the gaps by developing obligations on the basis of the duty to prevent or relatedly the due diligence principle. And so here what courts have tended to do is if the treaty or the instrument underlying the action contains a duty to prevent, or to look at it another way, would hold a state responsible for an omission, then progressive and sort of interesting interpretations of that can be applied. So the Genocide Convention, for example, requires situations where states have a duty to prevent. And that's been a way of filling some of the gaps. Even if you can't show control or attribution, you might find a state responsible for the duty to prevent. There have been efforts to advance novel approaches on this. I think the Mothers of Srebrenica cases in the Netherlands are a good example of this, where for a while, effective control was interpreted to be who has the power to prevent a certain action. And that did get some traction with domestic courts until last year's decision by the Dutch Supreme Court, in which it sort of reversed that trend. But anyway, I think the duty to prevent is sort of an interesting way in which some of the limits of the state responsibility articles have been addressed. And similarly, the due diligence principle, which is related as well to the duty to prevent, is a way that certain states and non-state actors too are required to demonstrate a duty of effort, although not necessarily of result, in terms of taking measures to prevent certain activities which may be harmful. This way of filling in some of the gaps has certainly been important in terms of addressing some of the perceived shortcomings. Let me just flag a couple of other areas where I think that there have been some developments in terms of trying to overcome some of the perceived shortcomings or ambiguities in the articles. I mentioned at the outset that there are draft articles on the responsibility of international organizations. And the ILC's point of departure there was that international organizations may be responsible in certain circumstances, either on their own or when they act with states. And so the ILC certainly proposed ways in which Article 7 might help to regulate international activities. I think what's interesting about those provisions is that they set up the analysis such that it's either the international organization or the state that would be responsible, unlike the articles on state responsibility, which just ask, is it a state act, essentially, through the articles on the tests that we see in the articles. But the articles on international organizations take a corporate analysis. They look at piercing the corporate veil. The idea of shared responsibility, plurality of actors, or business and human rights, which would be based on voluntary standards, also fill some of the gaps that we see. So what does the future hold? I think that the rules under Article 4, institutional links, and the rules under Article 8, which really deal with control, are fairly settled. But there is a lot of movement with regards to parastatal or state-owned entities under Article 5. And that's due in part to the rise in activity of state-owned entities, as I mentioned before. But I think also the fact that we are now confronting very different legal cultures and different histories, really, with regards to how states interact with corporations. And I agree with Gunjan's statement that the ILC articles, despite trying to be agnostic on this issue, in fact, are not. And it's really a contemporary and important issue with regards to whether there is an international standard that helps us to determine whether an activity is a public act, a governmental act, or whether it's a private act. Now, there's generally speaking, I think, a lot of special rules about state-owned entities because of their market distorting behavior. They're exempt from domestic laws in many instances. They're protected from competition. Sometimes the boards of directors can be politicized. Certainly in certain instances, there's low levels of transparency and accountability. And that's why there has been an effort, particularly by organizations like the OECD, to promulgate certain standards with regards to corporate governance. And although the commentaries to the articles on state responsibility say that legal culture is relevant, in fact, I think what we see from the case law under Article 5 is there's a great deal of inconsistency with regards to what tests the articles actually, supply. Tribunals emphasize differently whether it should be ownership, function, or authorization. And so it's difficult in these matters to know what objectively the test should be. In addition, I think the cultural differences are really significant. You know, in China, the state owns more than 51,000 enterprises, and I compare that to the United States, where there's really very few government organized or government-owned enterprises. Fannie Mae and Freddie Mac, two banks that deal with the two banks that deal with sort of lending are two examples of that. Nassau might be a state-owned entity, but these things are actually very much a cultural issue and a question of some discussion. So I think the crux of the issue here is who gets to determine what's public and private. Is it a question of domestic or international law? And the answer to that question has implications not only for the articles on state responsibility, but also for neighboring fields such as bankruptcy and immunities. So to conclude, the crucial test is really, are the articles able to promote better compliance by states with primary rules of international law? Do they help to restrain wrongful acts in areas such as protection of the environment, security operations, foreign investment, human rights? And I believe that they have in many of these areas, and that in areas where they haven't, states have been able to come up with alternatives, like I've suggested, different approaches. But, you know, an area of growing concern is where states operate through or own enterprises that have mixed commercial and public purposes. And I think this is an area where the articles do need to be updated, where we need to look carefully at what Article 5 means in practice and develop some consistency in the tribunals and the awards, because if we don't, it creates an access to justice problem where it's difficult to predict and difficult to rein in some activities of states. So I'll leave it there, and I look forward to the discussion. Thank you.
Thank you, Kristen. So let me, and I encourage the audience to keep sending questions in, but let me start with a question for the whole panel that combines comments and questions that have been made by Hina Sial and Nick Dangerfield in the Q&A box, and also with a question of my own. And I want to stay on this theme of attribution that we've heard from, in particular, Kristen and Gunjan. And I want our speakers to think about Articles 8, 5, and 16. So the question on Article 8 is that the debate about effective control versus overall control a dead letter? Or is there still life in that debate? And if so, do you have a view on it? On Article 5, I think Kristen has laid out many of the challenges of applying this article and having any consistency in terms of what's a governmental activity, what is a state entity that comes under Article 5. We've heard from Kristen on some of her proposals. I'd be interested to hear from Gunjan or Christian as well on whether they think Article 5 has stood the test of time. And then specifically on Article 16, Nick Dangerfield had asked whether the threshold for liability, both under Article 8 and Article 16, is so high that can the panel actually envisage circumstances in which a state would have a wrongful act attributed to them under those articles? So please pick and choose. You don't have to respond to every aspect, but under the theme of attribution articles, I would ask perhaps Christian to start off.
Thank you, Philippa. Thank you, everyone, and thank you for the questions. I think Article 8, of course, is one of the focal points of the debate. And if you want, in my benevolent account, that this is all sort of a common language, it's all nice, it's all successful, it's one of the more debated aspects. Now, I think perhaps I'll start with Philippa, your question. You wondered whether the debate between different visions for Article 8, different ways of construing it, effective control, whether specific versus specific control was dead. It seems to me, it seems to me that as a matter of the mainstream orthodox view, there's now more support for the ILC's position than there was in 2001. Not so much of the ILC's making, or not so much because I think on Article 8 we have all these hundreds of judgments accruing to it, but because the matter has been addressed in a particular context, but in general language, by the one interpreter in international law, which is more authoritative in giving us guidance and imprimatur to competing approaches than the ILC, and that's the ICJ in the Bosnian genocide case. And it struck me that the ICJ siding with the ILC in that case for a narrower, more particular vision of attribution rules based on Article 8, also on Article 5, but in particular Article 8 has, I don't know, I mean, in class I always say that's the Empire Strikes Back or some sort of equivalent to that. It seemed to me that it's pretty difficult to, in general international law, to get a view approved that is rejected by the combined weight of ICJ and ILC. So it seemed to me that as a, if you wanted to advise somebody on can you open this up, it seems difficult to mount a head-on attack because it seems to be fairly consolidated that you have to show control over particular acts. It seemed to me that from within there was a lot of room to perhaps play around, because it seemed to me this debate sort of Nicaragua versus Tadic was perhaps a bit too polarized, and really it depended a lot more on factual patterns or on how you construe things, also on the obligation that you're trying to establish responsibility for. So I think below the surface, I think there's room for argument. At the level of the principled opposition, I would say, is it dead in the water? It's pretty difficult, I would say, to challenge the position that the ILC put forward and the ICJ, well, that the ILC put forward relying on the Nicaragua judgment and the ICJ subsequently endorsed for the construction of Article 8. One follow-up comment is that it seems to me, and this ties it back to sort of something that Kristen was saying, and may perhaps also, Philippa, be a response to what you were saying, or what was one of the questions in the chat. It seemed to me nothing stops anyone from thinking of rules of attribution that do not follow Articles 4 to 11. It's sometimes, it seems to be overlooked as if these were really set in stone. It seems to me that many of the fields cry out for special attribution rules. It may be that, Gunjan, your point, investment arbitration is one. It may be, Kristen, state-owned enterprises sovereign wealth funds in particular, might be subject to a particular rule. And under this blanket point, I think none of us mentioned Article 55. The ILC rules are general, but they're residual, so you can always create special rules. It seems to me precisely because the ILC in the attribution rules is relatively clear, those might be a good candidate for special rules and attribution. And I think we might perhaps talk more about those special rules rather than about sort of principled opposition between different constructions of one of those rules. Thank you.
Thank you. Gunjan, any thoughts?
Yeah, I did. I support all that Christian said, but Nick Dangerfield's question was put in a certain way, and he said, can the panel envisage circumstances in which liability would actually arise for the state to which the wrongful act could be attributed? And this has brought to my mind what is one of the most difficult parts of legal practice, of international practice, of any legal practice, and that's evidence. That's the concept, Professor Boon mentioned access to justice. It's difficult to raise and substantiate a legal claim. And international law, I think, is starting to come to grips with that fact, especially in the field of investor-state arbitration. But as we no longer consider disputes to be state-to-state disputes only, as we give force and legal persona in international law to individuals, to investors, to humans, to individual persons, to corporations, as we give them a role in the crafting of international law before tribunals, one of the things I think international tribunals really need to get a handle on is sometimes a meritorious claim will fail for lack of evidence. It's just the way it is. And the reason meritorious claims need to fail for lack of evidence is so that unmeritorious claims don't move forward in a way that makes states think, okay, well, this isn't really a system designed for justice, it's a system designed to hold our feet to the fire. You need to rely on evidence. And so, yes, it is difficult sometimes to make evidence of conduct or direction or control or effective control or control over the acts. It is difficult. And sometimes you have to proceed by inference. And inference is the highest standard in the Corfu Channel case, right? If you're proceeding by, if you're proceeding through circumstantial evidence, but it can be done with the right counsel, with the right investigation. It's just not easy. And this idea that access to justice requires us to unburden ourselves of evidentiary standards of proof, I think is problematic. And you're seeing it happen before international humanitarian tribunals, especially, right? Where it's no longer the world where the facts are agreed, where the investor and the state agree on the facts and then say, what's the legal consequence? Or the two states agree on the facts. But I don't think that makes it impossible. I just think it makes it hard. And there's a difference between the two.
Thank you. And Kristen, I know you addressed a lot of these points, but is there anything you'd like to add before I move to the next question cluster?
Sure. I'll just make two brief comments. I think one thing that's interesting to notice that in the articles on responsibility of international organizations, their effective control was the adopted standard. So unlike the articles on state responsibility, which leave the question open, it's actually quite specific in that context. And the second thing I would say is that with regards to Article 8, in the investor state context anyway, it's difficult to actually reach the attribution thresholds. There aren't that many cases where entities have actually been thought to, or the state is thought to be responsible under Article 8 for activities of entities. But I think that it's a little bit different in the human rights context. I think the human rights context, there's actually been a lot more successful claims that have been brought under Article 8. And so I guess the question is, in the human rights context, does that suggest that graver harms like human rights abuses should have, do they in fact have different thresholds? Are there different evidentiary standards that are applied? And there's certainly a line of cases before the European Court of Human Rights, one involving Moldova and others in which, there were successful claims that were brought under Article 8. So I think that this question of control, I think it's been settled in large part, but the difference between the human rights cases, I think in the investor state cases is actually quite interesting. And that might be where there's still some action and some developments with regards to standards. Thank you.
Thank you. So in 2001, Greta Thunberg wasn't born yet, which makes us all feel very old. And that leads into a theme of questions we've had around climate change and sustainable development. And I'm referring to questions from Javier Suraski and Maria Fogadestam-Agius, and I'll ask both of them, and panelists can choose how they'd like to address them. So Professor Suraski asks, how do the ILC articles, encoding the language and having led to a common approach to responsibility, support the assignment of responsibility in the field of sustainable development, considering it's made mainly of soft law at the moment? And then Maria Agius's question is, she'd like to hear the panelists' views on whether the law of state responsibility is well equipped to deal with contemporary issues where causation is complex, such as the consequences of climate change. Kristen, maybe I'll start with you.
Sure, thank you. So one area where I think we might see some developments, both on sustainable development and environment, has to do with this due diligence principle, right? To the extent that treaties are interpreted as requiring states to do things, right? Then we can attach liability. And I think also the underlying contracts and concession agreements can often be quite interesting in this perspective, because it's not uncommon to embed certain principles, whether those are labor rights or references to human rights or the environment in those circumstances. And so sometimes, those principles come up not through the treaties or not through the articles of state responsibility themselves, but through underlying concession agreements. And so that's one angle, I think, on this issue. Another point that I would make, especially with regards to climate change, is that, I think it's becoming apparent that state-owned entities have actually been responsible for, a fair number of environmental harms. And so one area to watch going forward is whether claims are brought against states and state-owned entities from an environmental perspective in order to try and bring responsibility in that area.
Gunjan?
I think climate change is particularly difficult to attribute fault to take up Maria's point. And hello, Maria. Maria and I were colleagues of Volterra Fietta until quite recently. Climate change is particularly difficult to attribute fault to because at the time that most of it occurred, it wasn't internationally wrongful per se, right? At the time that most of the what's causing climate change today occurred, either there wasn't an understanding or more appropriately, there was an understanding, but there was kind of a let it be approach in international law. And today, now there's a new norm developing that we have to prevent the collapse of the ecosphere, which is probably good for all of us. So it's difficult to attribute fault to climate change having occurred and is occurring. But where fault is being attributed in climate change litigation appears to be in the omission of states to address it today. And that's easier to attribute. That's easier to see as wrongful misconduct because it's again, conduct, omission. And the omitting factor it's the failure of states to address something that's happening today and we know is happening that is leading to findings of fault such as before the Dutch Supreme Court. It's not about who caused climate change, and it's quite obvious who did, and the industrial world contributed greatly to it, but the developing world as well, and most people ignored it, et cetera, et cetera. It's about the omission. And I think in that circumstance, the ILC articles seem to make perfect sense. There's an international obligation, you have to do something about it, do something about it. And that I think follows the structure quite well.
Christian?
Thank you, Philippa. Let me address Javier's question on that you read out to us, Philippa, on whether the ILC's text could help address questions of sustainable development. I think, and then there was also a reference to soft law. I think my response is in two parts to that. One is the ILC's text are of little help to the extent that we're dealing with soft law if we're working with those assumptions. It presupposes a breach. This follows from what Gunjan was showing to us as the central provision of the text, a breach of international law. So to the extent that we struggle to establish that because the primary rules are unclear, I think the effect of the ILC's text will always be limited. Now, we may discuss whether it's really so problematic or whether not through developments that Kristen in particular has outlined, due diligence, recognition of duties of prevention, hardening of soft law rules into something that is, after all, binding. That step may not be overcome. But I think if the premise is, can we work without an established breach of international law, then the answer is no. The second point is, I do think the ILC text has clarified certain things and has, if you want, made international law fit for purposes for the types of debate about climate change and sustainable development. And this is something I was trying to set out in my presentation, but perhaps did not do so well. So what I had in mind is really that it has, if you want, removed preliminary barriers to addressing questions of sustainable development and climate change through the prism of responsibility. And it's a counterfactual, but you might say if the Ian Brownlees of this world with a causes of action led inquiry had their say, then I think we would struggle a lot more if the debate was still like it was in the German Society of International Law in the 70s and 80s about there can be no responsibility without damage. We would be stuck with lots of problems establishing damage through failure to, let's say, comply with climate change requirements. I think the ILC text is elegant in that it removes all this and says these are not principal requirements for talking about responsibility. All you need to show is that there be a breach. It doesn't matter whether it had caused damage, however you define it, and it doesn't even matter for the purposes of invocation whether you're damaged or specially injured in any subjective sense. It makes, this was the reference to Article 48, which I tried to mention, it makes room in a large way, in a significantly progressive and liberal way, for invocation of responsibility in the interest of a collective public interest. So I think these do not really make sure that state responsibility is your friend when you want to argue about climate change. But I do think the modernization that the ILC's approach has brought with it removes obstacles that otherwise in other systems that work with bilateral claims, with damage, with fault, hinder the idea of litigation about public interest goods. Thank you.
Thank you. And I now turn to Richard and then Rosanna to ask their questions.
Sure, thanks very much, Philippa, and thanks also to all the audience for the questions so far. It's sort of tying into Christian's first point about the common language and that generally applicable framework. And what he also said was the development of special rules across different sectoral aspects of international law. And I'm just wondering, curious to hear the panel's views on whether moving away from a general framework would actually be that problematic if more special rules were to develop.
Christian?
I think my response would be at two levels. One, I mean, formally, it's not problematic at all. And I think the strange thing is how completely we take state responsibility as a framework on board, given that international law otherwise, we talk about fragmentation, about regime specialization. So state responsibility seemed to be one of those cross-cutting notions and concepts and operative regimes that seem to work against and despite fragmentation. And so I think that's one of the features, perhaps not a reason for its success, but one of the features of the success of the text, and shows just how embedded it is, including in specialized areas. So, but I think if special areas choose to use different language, different concept, different notions, then I think there's in principle no problem with that. And the ILC would be the least to say, hegemonically, it must be the text we drafted. Article 55 is express on this to the extent that special regimes follow special rules. There's nothing in the ILC's text to stand against it. I do think the fascination with the ILC's text, which I share and of which this seminar is of course a reflection, has sometimes precluded us from seeing how many such special regimes exist and continue to exist. This goes to something that Kristen was hinting at. I think it's explored interestingly by various scholars. There's a work by Katja Kreutz about how state responsibility, in the sense we've been discussing it, had moved from paradigm to periphery, because the real momentum was now in fields that understood responsibility or functions associated with responsibility differently. International criminal law, liability, where we're not looking at breach, perhaps compensation schemes outside, liability for hazardous activities. Maybe those are more suitable. And maybe, as much as I've said that the ILC's text is modern and open, has been adapted, maybe we're just stuck with a system that is not meant to deal with questions where attribution cannot be lightly proven, where we're working with private-public distinctions that are ingrained, and where remain premised on the idea of state obligations. So I think the ILC has not moved out of these shoes, and perhaps the fresher regimes, the fresher debates of responsibility are had in different settings that work with different notions of responsibility. Now, from the ILC's point of view, nothing would stand against it. The fact that the ILC has been so successful in monopolizing and dominating the debate suggests that there may be sort of some inhibition to move completely out of the framework. Thank you.
Unless Gunjan and Kristen want to come in on that, I'm going to turn back to Richard, who has a follow-up.
Yeah, it was just a quick question to all the panelists. Do you think the authority of the combination between the ILC and the ICJ is actually more important with respect to the development of state responsibility than the practice of states themselves?
And that exact phenomenon has been described by Christian as normative ping pong, which I thought was a very apt description. Who would like to come back on that? Gunjan?
Yeah, I think the answer is no. I think it's the ILC's work is excellent. The ICJ's work is important. It's really useful to us as practitioners, as academics, as thinkers. It's useful to people to know what states can or cannot do to them. under international law. So these are all very important work. But at the end of the day, the primary focus of international law remains these massive gargantuan entities that monopolize violence called states. And if states are agreeing to these special regimes, which, as Professor Boon pointed out, they are agreeing to these special regimes, that's going to have a predominant influence. That's what people on the street are going to care about, because that's what their governments are telling them is the rule, and that's what their governments will act in compliance with. What's really happened with the ILC articles, I think, is because they're so well written and so well drafted. Criticisms aside, they're very well written, they're very well drafted, they're very easy to understand, is that states have become to adopt their thinking, right? This is how I am subject to potential liability. This is how I should behave. And that, I think, is pushing them forward just as much, or probably more than the ILC or the General Assembly, or even, dare I say it, the World Court, for all its augustness. We are still in a world of states, and it's still the Westphalian system at the core of what we do.
Thank you. And I'm now going to turn to Rosanna, who has a question in the first place for Kristen.
Yes, thanks to all the panelists for this excellent debate. My question is for Kristen, and also to some extent for Christian. So going back to the idea that we sometimes see human rights violations in which state-owned companies are involved, often with mixed public-private ownership, in states that may not have ratified the relevant international human rights treaty, but may be supporting the UN guiding principles on business and human rights. And I'm thinking, for example, of labor rights, which Kristen also referred to. In those circumstances, the ILC articles are still explored as an avenue to accountability. And I'm just wondering, going back to Christian's and Philippa's mention to the ILC articles having created a language that we all engage with, I'm just wondering how you see the articles evolving in this sense in the future. I know that Kristen, for example, has been looking at some interesting trends having to do with positive obligations to find a way around the difficult application of some rules of attribution and the slippage problem. And it would be interesting to hear your thoughts about whether you think the use of the ILC articles to bridge that non-ratification gap is reasonable, or is it too much of a stretch? Thank you.
Thanks for this question. Yes, this is a very important issue, and I think it does reveal gaps in the legal architecture, frankly, with regards to the states that we're talking about and the sort of norms that are considered to be customary international law or erga omnes obligations. I mean, obviously for certain, specific types of acts, one could make the argument, that forced labor, for example, or slavery. I mean, these sorts of things I think would be in a different category. And because we could use the articles on state responsibility as a community basis in order to try and deal with some of these. But in the more regular types of cases, I think what the articles offer us is a language. They don't offer us solutions because of this importance of identifying the hard treaty commitments or hard instruments that apply in these circumstances, but they do give us a sense of the what the consequences would be. I think there's reputational issues that come up for states in these circumstances. And they do show us a path forward, whether the answer lies in the articles on state responsibility themselves or in developments in more specific areas, I don't know. But I think that you have identified a real issue here, and again, if we can't kind of rely on the erga omnes obligations or issues that really do have universal consensus, despite gaps, we operate in a soft law area in a way in order to urge states to comply, to ratify various treaties, or to use the language from the articles in order to try and signal the importance of different outcomes.
Can I, Philippa, add one thought? It's really on an aspect of Rosanna, your question, and that goes to the future development. What strikes me in looking at the ILC, sort of echoing Kristen's point that they cannot be faulted for what they were never intended to be, namely rewrite international law in a progressive image. They are the background rules that reflect a rewriting in a progressive image and make it operational. And I think that's what by and large they do. But of course, perhaps in retrospect, I would say I probably overstated that, because one of the things that has clearly emerged from the discussion and is an element of my response to your question is that for attribution, that's probably not the case. I think for attribution, the ILC has tried to open up, but has been more restrictive than in its general vision of modernizing responsibility. And now I think that's why in that field, echoing Kristen, there may be an obstacle to using the language. We may need special regimes. I think just to throw in one consideration, which I think could help with some of the points that, or some of the tensions, or some of the challenge that you mentioned. I think the other example where the ILC has really been, I think, breaking new ground is Article 16. That is the opposite of the attribution articles, which are by and large a bit traditional. Article 16 is I mean, I don't know, is that idealistic, or is that dramatic, or is that illusionary? The idea that for each and every obligation, you could in principle have bystander responsibility, irrespective of whether the special rules say that, as they say for genocide, or as they say for aggression. For each and every breach of international law, if you contribute, if you aid and assist, you're in principle not immune from liability, not before any particular court, not before any particular forum, and not if the rules are not established. But the idea that you would widen the circle of potential litigants, and you could act against those whose responsibility in probably common law terms is vicarious, is, I think, groundbreaking and revolutionary. And that is a really sort of an opening up towards a more community obligation oriented discourse in which we hold states responsibility, or at least we envisage the possibility of holding responsibility for something that is not mainly their fault and not mainly their conduct, but where they simply contributed. Now, you mentioned labor rights. The one example which I would just mention, as I think goes back to something that was debated in a previous round of questions and answers, is extraordinary renditions before human rights courts, for example, where exactly that was at stake. And again, the ILC's framework did not stand in the way of litigating it, and perhaps lend credibility to attempts to widen the circle of states that could be acted against. Thank you.
Thank you. And I'm going to turn in a second to Richard, who's going to wrap up this discussion. I'd just like to thank the audience. A lot of useful comments, not necessarily questions in the chat, and also, I mean, just showing the wide range of interest in this topic 2 decades on. In 2022, it's on the agenda of the General Assembly to consider again whether there should be a treaty on state responsibility. It comes up every 3 years or so, and as we know, James Crawford was very much against the idea, but it will be on the agenda again in 2022. And it sounds like, at least from this discussion, that it's not really a treaty or the codification in formal terms that we need to think about, but more about these special regime rules and the opening up of articles like Article 16. So over to Richard. Thank you.
Thanks very much, Philippa. So I've been given the pleasure of wrapping today's event up. And I just want to do that by thanking everyone that participated, including our fantastic events team doing much of the work behind the scenes and also helping bring everyone together today. I want to thank Rosanna in particular for introducing the event and also helping me and my colleague Jean-Pierre organize it. Thank you also again to Voltaire Fiera for funding the event. And particular thanks to Philippa, our fantastic chair, for moderating this really interesting discussion, and our cracking panel of speakers for their time and also providing us with many interesting insights on state responsibility. And last, but certainly not least, thank you to all of you in the audience for coming along and tuning in. And I just want to remind everybody that the recording of the event will be available on our website. And feel free to get in touch and or follow us on social media to learn more about the work we're doing, not just in the area of state responsibility, but in other areas as well. So basically, wherever you are, whether it's morning, afternoon, or nighttime, take care of yourselves. And thanks again for participating. And we look forward to hosting you again in future events. Thank you.